Every day in the USA, people find themselves in court.
I'll go ahead and call our next case. It is cause number 2025 DCV 0542, France Pierre versus Claire Shamblin Caton, Sanel Van Wyck et al. May I have announcements, please? Mr. Pierre, if I could have your announcement.
Yes, my name is Franz Pierre.
Thank you, sir. And your attorneys appearing?
Morning, Your Honor. Rob Negrin. The last name is Negrin on behalf of McCarthy Holthus LLP.
All right, and we are set today on, I believe it's Mr. Pierre's motion. What is the title of your motion, Mr. Pierre?
My title of motion is there is a second amendment to the direction for rent collection in El Paso, ma'am. Is the second amendment.
When was that one filed?
That one was filed last week. I do not, let me see if I can give you an exact date, ma'am.
I'm showing July 2nd.
That was the second amendment. There was an first amendment that was filed a week or 2 weeks prior. The second amendment was filed last week. Yes, ma'am.
So you're asking to proceed on the second amended motion for court directions on tenant payments?
Yes, ma'am.
And that was filed on July 2nd?
Yes, ma'am.
Okay. All right. Counsel, did you receive a copy? I'm just wondering if people are getting served with these. Does everybody have this document? No? I'm seeing heads shaking no, but so obviously when the court scheduled this, Mr. Pierre, it was on, I don't know if even if it was the first amended, but it was since on our last hearing. I know you already had a live pleading because if memory serves, you were may have been asking to go forward at that time, but the court wanted to make sure we had ample time for parties to have received, reviewed, and been able to respond to your motion. Now we have a second amended motion. And so I need to say, Ms. Caton, are you appearing? How are you appearing today? I'm seeing your head shaking and not hearing anything else.
No, Your Honor, I'm here solely today on special appearance to challenge the court's personal jurisdiction over me.
Okay. Okay. All right. Mr. Negrin, did you get a copy of the second amended motion?
Sorry, Your Honor, I was muted. I received something, but I'm not exactly sure that it's the second amended.
Okay. Mr. Medina, are you showing that these are getting served on Mr. Negrin in the e-service?
Let me go ahead and check that for you, Judge.
All right. While he checks on that, Mr. Pierre, whenever you're ready, I'll go ahead and hear your argument on your second amended motion.
Your Honor, I do have a copy of the plaintiff's second amended motion for court directions on tenant payment and preservation of tenant rights.
All righty. Thank you very much. Mr. Pierre, you may proceed.
Yes, ma'am. Good morning. They're going to turn the music down a little bit. Ma'am, thank you for this opportunity to present this second amendment to the direction and guidance for the El Paso rent. At the crux of this issue, or at the crux of this case, is not to challenge Ms. Claire, is to challenge that the Virginia order has not been domesticated in Texas. I am not challenging who she is. I am not challenging what she does. I'm challenging the way she does some things. For example, as you may be aware, on the 21st of October of 2024, I had fired Miss Aguilar. Therefore, she does not represent me from the 21st of October. That is on an exhibit, I believe is exhibit B in front of you. It will show that Miss Aguilar was fired. Now, there is a contract that was signed on the 23rd or the 24th. That's 2 days later, but I did not sign that contract. It was signed under duress. Since Miss Claire was appointed from Virginia as Commissioner of Sale, she has never domesticated her order in Texas. However, Mary has been taking directions from her. So Mary, since she got fired, she should not have been collecting the rent. However, Mary has been collecting the rent and held on escrow, and that has created great harm to myself and my property. Now, it is very clear that Mary was fired on the 21st. The question is, why is Mary continue to collect rent? There's an email that is attached. I believe it's K or L. I do not have it in front of me. It shows that Mary is in communication with lawyers in Virginia. That communication stipulate that she need both signatures in order to transfer the rent. However, Mary does not have my signature, and I do not believe she has Sanel's. Now, why does Mary continue to collect the rent and not stop collecting the rent since the time she was fired? Ma'am, she was under the impression that Miss Claire has all the authority from Virginia to dictate and direct where the rent goes. Now, I show you that the rent since then collected is about 11,000 plus the security deposit. Mary continues to collect the rent, and I believe she turned it over to Miss Claire. Now, there's an attachment order that shows that Miss Claire, one, expressed to the court that she understood that she needs to domesticate the Virginia order in Texas. However, she has not. She also asked the court in Virginia to give her permission to take the rent from Texas, which she does not have Texas, she does not have Texas permission or a court in Texas because she has not domesticated the order. So Miss Claire is acting on a Virginia order, directing action and activities in Texas. That is against the laws in Texas. Now, because Miss Claire believes or her action in Texas is legal, I am asking the court to say that the Virginia order, since it has not been domesticated in Texas, it should have no impact or effect on what happens in Texas until it is domesticated. Again, at the center of this case is one, the domestication of a foreign order that is required by Texas law to be domesticated in Texas in order for it to be executable. However, Ms. Claire has not done so, but she has been directing and in communication with Mary about what happens with the rent. I fired Mary. She should not be collecting the rent. She should not be representing me on the sale of the property in Texas. She's fired. I don't understand why she continued to believe that she has my authority to do any action on my behalf. And there's nothing on the record that says that Miss Mary has permission from Sanel, who's the other co-owner, to do anything on the property. So it is it is extremely harmful to my property rights in Texas that Ms. Claire continues to direct what happens in Texas. She has not domesticated the order. So it is an illegal activity that she's performing with Mary and herself. So that is what I wanted to present to the court to show that Mary was fired, continued to collect rent, which is not authorized. She either hold on to the rent and passed it to Miss Claire because Miss Claire has stated that she wants to use that rent money that is collected in Texas by Mary, which doesn't have a Texas order, to use that money against me or to find a lawyer in Texas to go against me in terms of representing her in Texas. Even though she has not done so, the money is held, and I'm asking the court to, one, direct the tenant not to pay, not to give the money to Mary, and pay directly to the bank. It has an account. The money should be deposited there. The other issue is, since the rent has not been turned over to me, a big chunk of the reason that the house is in foreclosure in Texas is because they have not received payment. It's not the complete reason, but I would say 50% of that reason is because that rent has been collected and not been paid. I'm asking the court to have that money refunded and turned over to the bank. That's my presentation to you, ma'am.
Thank you, Mr. Pierre. And Ms. Caden, I'll hear you now on your special appearance.
Thank you, Your Honor. As you know, I was appointed Special Commissioner of Sale by the Fairfax County, Virginia Court. And I haven't taken one step in the state of Texas. I haven't even had a phone call about the El Paso property. I'm afraid Mr. Pierre is misinformed about how much communication or direction I have provided to anyone in Texas. I've been completely hamstrung in my obligations to the courts in Virginia by Mr. Pierre's continuous litigation. I couldn't sell the property. I haven't tried to sell the property because of the continuous lawsuits. No settlement company would touch it. I've had no communication with the tenants. I have never tried to evict the tenants. I have not collected one dime of rent. And Ms. Aguilar was following the Virginia court orders, which she was provided by Ms. Sennell's attorney. I had nothing to do with telling her what to do, but none of those rents rely on me. Mr. Pierre hasn't sufficiently alleged minimum contacts with Texas, which would give this court personal jurisdiction over me. Perhaps in the future, if I were to continue or be able to continue my role as Commissioner of Sale, that would be a different story. But as of now, I haven't been able to do anything in Texas.
Ma'am, I object to her statements on the ground that we are not hearing her motion on this issue today. The issue at hand is my motion to redirect the rent. I have filed an opposition to Ms. Claire's statements. I believe that should be here at another time, but if you choose to hear it today, there's an email on.
Mr. Pierre?
Say again, ma'am?
When did you file your opposition?
I filed an amended opposition to Ms. Claire. Are we hearing her conversation, her motion today?
I'm asking to find out because I do not see one in the pleadings when you filed it.
I did file an opposition. Let me give you the exact date, ma'am. Okay, ma'am, there is envelope number that ends in 1382, and it was filed on June 25th. And it was, it was filed on 24th June. On 25th June, it was accepted. And I believe there is an amended opposition that shows the different level of contacts that Ms. Claire, who stated that she doesn't have any contact in Texas, it clearly showed that she was in contact with MacArthur and and Holsis, because it was on her behalf that they took the home off foreclosure. The other reason that it's clear that she's had contact in Texas is that she described a conversation in our last hearing. She was not a party to that hearing. However, she's fully aware of what took place. For example, it was Mr. Bertrand who asked me for my residency. However, Miss Claire stated that in her
Mr. Pierre,
petition.
you're doing two things. You're telling me not to consider it, and then I'm understanding that you're arguing now on it. So in terms of the special appearance, and I am seeing now your opposition and motion to strike, the court is going to consider those via submission. You will have a response by the end of this week.
Yes, ma'am. Thank you so much.
Thank you very much.
So,
Thank you, Ms. Caton. If you don't have anything else, you're welcome to stay. But the court will be considering the request and Mr. Pierre's response via submission. I'll have a ruling by the end of the week.
Your Honor, would you require Mr. Franz to send me a copy? I did not receive a copy of his opposition.
So yes, we can, and I gotta assume you're not served because you're not on the e-contacts on the e-serve.
ma'am,
Probably not, but
she was on the
Mr. Pierre knows
e-console.
how to contact me.
Okay, so Mr. Pierre, you are do you have an email, or what is it that you have?
He has my email address, Your Honor.
Mr. Pierre, you're going to be required to serve Ms. Caton with your live pleading the opposition to her special appearance and your motion to strike.
Ma'am, can I have permission to send it by email because she has a PO box number?
Yes,
Her mail
fine.
by email,
Yes.
and I will provide the court that I actually sent it. I cannot confirm whether she received it or not because I don't have that. She's been part of this case since the beginning of me filing this, and she's been the clerk can shows that all the people that are served. But however, I will submit an email to Ms. Claire about my opposition.
Okay, anything else on your motion for court? Is it instruction? Anything else on that, Mr. Pierre?
Yes, ma'am. It's extremely important to rule in my favor because the money that has been collected needs to go to US Bank. That is 11,000 plus. The other thing to clear with the court is that the Virginia order has not been domesticated in Texas. For actions against any executable actions in Texas should be illegal. And I do require that the money that was collected, I showed you the receipt that it was sent from from Adriana to Mary. In addition, there's a document that shows that Claire is using that money or trying to use that money to file to use a legal system against me. It's important that the money return. It's important that the court state that her action in Texas has been illegal and it's all based on Texas law. And it's also important that there are damages to me that I actually laid out on what those damages are in terms of my credit, in terms of the opportunity that I've lost. I forgot all the other damages that I've put, but they are on the document, and I would ask that the court consider those damages based on the action that Mary has done, either on behalf of Ms. Claire or not. But she's actually held on to the rent money that should be going towards securing my mortgage and stop the default of my property in Texas, man.
Anything else?
No, ma'am.
Thank you very much. Mr. Pierre, the court is not in agreement with either the basis and or the relief that you are seeking. And so I'm going to decline respectfully to provide any direction and deny your motion. So we can generate, Jasmine will generate an order denying same. All pending motions, so the special appearance, the court will consider via submission. Mr. Negrin's motion to dismiss, which was filed today, will be heard in 1 week. If you are going to have a response, Mr. Pierre, please file it as soon as you can, as soon as practicable before that hearing. It may seem a little rushed, but the court anticipates being out of pocket for about almost a month on a trial. And so I want to make sure we address these things before scheduling becomes more difficult. So in terms of the scheduling status conference, I'm going to hold off on that. That's typically something that we would utilize to set future hearings. But in light of the motions that I think we're going to hear next week, we may or may not need it. So we'll set Mr. Negrin's motion to dismiss for Wednesday. We'll do 9 a.m. Mountain Time. Same thing on Zoom. And I will have a ruling for you on the special appearance and the motion, the response by the end of the week, okay?
Yes, ma'am. When should I expect the order of, I believe you said it's dismissed, or you do not have an opinion on that?
On your motion that we heard today, it's denied.
It's denied. Okay, ma'am.
Correct. So I'll get an order out as soon as I can.
Thank you, ma'am.
Let me see. Anything else for today?
No, ma'am.
All right.
No, thank you, Your Honor.
Thank you very much. Jasmine, if we'll just get this one scheduled for a motion hearing on Wednesday at 9 a.m., please. Thank you very much. Thank you for your time. You all are excused.
Thank you,
Your
ma'am.
Honor.